Today we're going to talk about copyright issues in online teaching. I modified my presentation slightly to take account of the fact that there are some rules that apply to full-time Senate member, faculty members that don't apply to instructors who are teaching one-off classes, even if they regularly teach one-off classes through extension.
So we're off the hook entirely, right? Working with campus, is that right?
Not so much. This is our agenda for today. We're going to talk briefly about copyright basics so that we're all working from the same general base of knowledge, and even more briefly about the purpose of copyright law, why your clients, the instructors, should care. We're going to explore under what circumstances the instructor or the university can be sued. And then we're going to get to the meat of what you all want to know, which is, what should I do? How do I analyze whether someone would have a claim? Can I get permission to use what I'm trying to use? Do I have Teach Act protection? Do I have protection under the fair use defense? Do I have any other options? And then we're going to close with a checklist and some resources for additional help. So, copyright basics. A copyright is an intangible right to exclude others. Owning the copyright in a work of authorship is not the same thing as owning the work of authorship itself. So, for example, if I were to paint a painting and someone were to be foolish enough to pay money and buy it from me, if we had no written contract, I handed her the canvas, she handed me $100, I still own the copyright. She didn't buy it, she only bought the painting. If she wanted also to buy the copyright, we would need to have a written agreement, and I would need to say, you're paying $100 for my canvas, you're paying whatever it is, X dollars for the copyright to that image. As it stands without a written agreement, she gets the canvas, she can do certain things with it. For example, she can lend it to a museum and put it on a wall in an exhibition. But I still control the copyright, which means I can exclude people from doing certain things, because that's what a copyright is, an intangible right to exclude. Almost anything can be the subject of a copyright. Copyright attaches to original works of authorship that have been fixed in a tangible medium of expression. So a couple things about that. The bar for originality is very, very low. Almost no matter what I painted on my fictional canvas that I'm going to sell, it would qualify, it would meet the originality requirement. It's that low, because I am not that talented. And then fixed, of course, is once you've taken pen to paper or canvas to paint, or if it's singing, for example, once it's been recorded in some kind of a mechanical means. The owner of a copyright, in the first instance, is the author of the original work of authorship. That's the default. And like any other property, it can be disposed of. It can be sold, it can be licensed, it can be bequeathed to the University of California, should you be so inclined. It's like any other piece of property. I mentioned that copyright is a right to exclude others. This is a list of what you can exclude others from doing. The copyright owner has the exclusive right to reproduce the work, to distribute the work, to prepare derivative works based on the work, and to publicly perform or display the work. If the copyrighted work is a sound recording, then the copyright owner also has the exclusive right to perform the work via digital audio transmission. In other words, the copyright owner is the only one who can do those things. Anyone else is excluded unless he or she has permission or an excuse, basically. Copyright protection lasts for the life of the author plus 70 years if the author is a human being. If the author is an institution because, for example, it's a work for hire, as this PowerPoint is, because I created it, in the course and scope of my employment as an attorney for the University of California. So the copyright in this PowerPoint belongs to the regents. How long that copyright lasts is therefore not measured by my life, which one can only hope will be long, but under the works for hire doctrine, so 95 years from the date of first publication or 120 years from the date of creation, whichever comes first. Those are the basics of copyright law. There can be a high level of frustration when instructors want to use certain materials and find that they're stymied in how or even whether they can use them because of the laws of copyright. So I thought it'd be useful to spend just a couple minutes on why we have copyright law at all in the United States. And the best example of that I've ever found is this quote written by Justice O'Connor in the Feist case, which was a Supreme Court case, where she says, "The primary objective of copyright is to promote the progress of science and useful arts. Copyright assures authors the right to their original expression, but encourages others to build freely upon the ideas and information conveyed by a work. This result is neither unfair nor unfortunate. It is the means by which copyright advances the progress of sciences and art." In other words, in the United States, copyright law is a utilitarian economic doctrine. The idea is you want to give authors enough protection so that they keep creating their works and making those works public, but you don't want to give them so much protection that nobody can use those works to go even farther in the future. Something to keep in mind when you're stuck in the minutia of can I use this image or can I not use this image? The source of copyright law, of course, comes from the United States Constitution, from the United States Copyright Act, which is Title 17 of the United States Code, and then many, many, many court-decided cases which are coming out almost daily. It's useful to remember that copyright is one kind of intellectual property protection, but it is not the only kind. The three main areas of copyright protection are copyright, patent, trademark, and then of course trade secrets is the fourth area that people typically think about. And there's a very good primer about how to tell when you have a copyright question as opposed to a patent law question at this link, which I put here for you. It's not long, maybe 15 or 20 minutes, and I highly recommend it. So, why should we care about copyright law? When I give this presentation to Senate faculty members, I spend a lot of time talking about the first side of the coin, which is the instance where we own a copyright and we want to make sure that our work is protected. I'm going to spend most of my time today talking about the second side of the coin, which is when somebody else owns the copyright and we want to make sure, as Justice O'Connor made clear that we have the right to do, that we use it in our own work, but in a way that doesn't infringe on the rights of the copyright owner. And so this slide talks about the difference between for works where you are the author, or more properly for you all, where your instructors are the author, and copyright protection for works where your instructors are not the author. So, focusing on how to approach whether you can use works in your instructor's courses when your instructor is not the author of those works. First, of course, everybody wants to ask the question, can I be sued, right? That's the big scary thing that might happen, and you want to make sure that it doesn't. There are three elements that need to be met before a lawsuit for copyright infringement can be successful. And they are that the plaintiff who would be suing you owns a valid copyright, that you have reproduced the copyrighted work, and that your work is substantially similar to the plaintiff's copyrighted work. And you can see I've put reproduced in red, and at the bottom of the slide I've added distributes, prepares derivative copy, or publicly performs or displays. Those are the exclusive rights that we talked about before. If all three of these things are true, then you're looking at a copyright lawsuit that may have legitimacy. You may ask, because you're all smarty pants and you know that the University of California is a public government agency, well, what about 11th Amendment sovereign immunity? Nobody can sue the University of California. And it's true, the 11th Amendment protects the university, and it protects university employees who've been sued for actions that they've taken in their official capacity. But it protects against money damages only. It doesn't stop a court from issuing an injunction telling the university what it must do or what it can't do. So it doesn't kill the lawsuit entirely. And of course, it doesn't protect individuals who are sued in their individual capacity. Individuals who are sued in their individual capacity still can be subject to money damages. The next question I always get is, well, will the university defend me, in other words, provide a lawyer, and indemnify me, in other words, pay the damages should there be either a court award or a settlement? And the answer to that question is that if the acts for which someone is being sued were within the course and scope of a regental employee's employment, most likely the regents would provide defense and indemnity. If they are outside the scope of a regental employee's course and scope of employment, then the regents would have the right not to defend and not to indemnify. All of which is to say that it makes sense to ask yourself, or for your instructors to ask themselves, not only are those three elements met and can I be sued, but what would the consequence be if I get sued? All of which leads us to, what should I do? We've talked about asking yourself, would the plaintiff have a claim? We're going to talk about getting permission, the Teach Act, fair use, and other options. Again, these are the three elements that need to be met in order for the plaintiff to have a valid copyright claim. So you may ask yourself, as you're going through this analysis of whether anyone owns the copyright, does anyone own it? If it was created before 1923, then of course it's fallen into the public domain. It's no longer protected by United States copyright law, and anyone may use it. You may ask yourself, since we do work for the University of California, whether the University of California owns it, because if the university owns it, then you don't have a problem, of course.
If something's in the public domain, it means it doesn't have to have any kind of attribution with it if you use it, it's just...
So this is a good opportunity to talk about the difference between copyright law and complying with copyright law and plagiarism. I often have people coming to me and saying, well, I don't understand. I said that this painting was by John Smith, so I've satisfied copyright law. That's a plagiarism issue. You've been forthright with the world and saying, John Smith made this painting, I didn't make this painting. So good, you haven't violated any academic dishonesty rules, but John Smith may still own the copyright to that painting, and so you may have needed to ask his permission before reproducing it on your website, for example. It's two separate things. The second question, of course, is, am I reproducing the plaintiff's protected work? Also, distributing, preparing derivative works, or publicly performing or displaying. I want to talk here about the difference between posting someone else's work, which of course would be both reproducing and publicly displaying, and posting a link to somebody else's work. If you post a link to somebody's work, most courts have held that you are not violating the copyright owner's exclusive rights.
Going to jail.
What if you post a link to somebody who is violating their rights?
I would try to find a link to the work itself, one where you can say with some degree of certainty that the owner of the copyright is responsible for it being there in the first place. That's the safest thing to do. And then, of course, the question that Jesse asked, which is, how do you know if it's substantially similar? Question of fact for the jury to determine. I would say use common sense. If you're not sure, ask 5 people and take a 3 of 5. Once you've gone through this analysis, ask yourself, based on all three of these requirements, do I think I have an issue? If so, let's move on to the next step. The first thing to ask yourself is permission. Do we already have permission to use this work? For example, if you're using an article that is in the UC libraries and to which we have a subscription, we may have the right for you to use it in this particular way. The thing to do is to ask the libraries, of course, if the subscription includes the use that you're thinking of. You may be able to get permission easily. It may be that your instructor, who you're helping do the instructional design for, may know the author of a particular article that she wants to use in her course. They may be colleagues, and she may be able to ask the author if she can use his work. There is also a really great resource called the Copyright Clearance Center. I believe their website is ccc.com. And if the owner of a copyright has made his or her work available on the Copyright Clearance Center's website, it's a very straightforward process to take a license to use it. Yes?
When you talk about getting permission easily in your
Mhm.
example of, getting permission from colleagues and whatnot, how many, how detailed do you need to get? Do you need to put together an official agreement to get permission? Does it need to be through an email? Can it be verbally? How specific do you need to get on something like that?
It doesn't need to be a pages and pages long contract. It should be in writing, and it should identify the work for which permission is being granted, the use for which the permission is being granted, and any fee or any lack of fee that's being asked and paid, and any limitations on the use. So only for 1 year from today, or only in the United States, or only in educational works, not in commercial works.
Okay.
And then it should be signed and dated by the owner of the copyright. And the thing about copyrights that is very handy in this regard is that they can be sliced and diced in so many ways. I like to think about it as my sister asking to borrow my car. If she comes to me and says, hey, I need your car, and I throw her the keys, we don't really know what happened, right? Did I give her my car and now I need to go out and buy another one to use? Or did I have some secret understanding that she's going to take it right now, but she's going to be back before my dinner date tonight? If I ask her some more questions, she may say, I'm going to take your car. I need it on Saturday to go get groceries, and I need it on Sunday to go to the beach. Now I have some more information, and I can start slicing and dicing, and I can say, it's fine for you to borrow, not have, borrow my car on Saturday to go get groceries. You may not borrow it on Sunday to go to the beach. These are some of the limitations that I'm talking about. I'm not aware of any cases that say that extension is on either side of that divide, but I can say that, and we're going to get to the fair use analysis, I think that extension has a more difficult argument saying that it is purely educational than, for example, the main campus would. So I think you need to keep that in the back of your mind. And if you're drafting, I'm sorry, what was the name of the woman? Natalie. If you're drafting the kind of permission slip that Natalie's talking about, if you think that's going to be an issue, then just be clear in your drafting and say, for use by the University of California, Irvine extension in the following ways. Then there's no argument because you've made an agreement and you've clearly discussed what it is. The second thing that may be helpful is that the use your instructor wants to make of the copyrighted work may be protected by the TEACH Act. The TEACH Act is part of the United States Copyright Act. It was added in 2002, and it recognizes the expanded use of teaching in education. Some people think that it hasn't developed as quickly and as robustly as the use of technology in education has, and that's something that's sort of inherent in federal legislation. It's really hard to keep up with the pace, especially of technology in the real world. The thing that is important to know about the TEACH Act is that in order to qualify for TEACH Act protection, you must meet all of the following requirements in the Act, and it is a lengthy list, so we will go through it. But if even one of them is something that your instructor's use doesn't meet, then TEACH Act protection is not for you. So, the institution must be an accredited nonprofit educational institution. There's no suspense here, the University of California qualifies. The work that you are using must not have been produced for mediated instructional activities. The way to think about this is that if a company that exists solely to create educational books were to find out that its books were being used online for free by other educational institutions, it would have lost a large part of its potential market share. If, on the other hand, what you've taken is a portion of a novel, which is produced not for mediated instructional activities, but for reading and other cultural and artistic purposes, then you haven't eliminated an entire expected market share from the author. Next requirement of the TEACH Act, the copy that you have must have been lawfully made or acquired. Nothing pirated, in other words. The next requirement of the TEACH Act speaks to what work you're using and how much of it you're using. If you're using a musical work, you can use the entire work. If you're using a non-dramatic literary work, you can use the entire work. Any other work, you can use a reasonable and limited portion. The next requirement of the TEACH Act is that the use must be at the direction of the instructor. It must be an integral part of a class session that is a regular part of systematic mediated instructional activities. Can't just be homework assigned, right? And it must be directly related and of material assistance to the teaching content. In other words, it has to be relevant to the course. The transmission must be only to students officially enrolled in the course. This is an issue of passwords and the like. And it has to be available only during the class session, so for as long as the quarter or the semester or whatever it is lasts. The institution must have policies regarding copyright, must provide information that accurately describes and promotes compliance with copyright laws, and must tell students, quote, materials used in connection with the course may be subject to copyright protection. I will represent to you that UC does have such policies and does provide such information. I typically advise faculty members to put it in the syllabus and at least once in whatever virtual platform they're using. So if you have an introduction somewhere, where the faculty member's contact information is, or maybe there's a brief synopsis of the course itself, that's the place to put information like this. The idea is the information should be someplace where you would actually think that someone would read it. Think about it as you think about disclosures when you're selling a house. You want to disclose everything. You want people to see that, because the more they see it, the less your risk is. Copyright law is medium neutral. It doesn't matter if you're talking about a piece of paper or a website or a song or something that you got from the radio as opposed to something that you got from a store. It's completely medium neutral. The only issue for the TEACH Act is that the copy that you have that you're about to put in your online course was lawfully made or acquired. In other words, if you ripped it where you shouldn't have, it's not lawfully made or acquired, you failed that element of the TEACH Act and you do not get TEACH Act protection. You would have to go through the same process that you go through when you are using any copyrighted work. You have to ask yourself whether someone owns the copyright to the work, and if so, do you need to ask permission, or do you have some other defense to having used it without? And it doesn't matter which medium you're talking about. You still have to go through that analysis. The bottom line, I think, for the TEACH Act is good for all of you, which is that it protects online courses. It doesn't protect course websites where faculty members sometimes post homework or supplemental readings that they want students to read outside of the course. I think it's critical that, and I'm sure this is the case with all of your instructors, that you use a campus provider. I have some faculty members on the main campus who just create their own course website, and then of course you don't get any of the password protections or the certainty of knowing that at the end of the course everything is going to be removed, and so then you've not complied with some of the requirements of the TEACH Act and you don't get that protection. When you tell students, quote, materials used in connection with this course may be subject to copyright protection, you can also refer them to this website, www.copyright.universityofcalifornia.edu. That's where the UC copyright policies are. And so if you do that, then you've complied with 2 of the TEACH Act requirements. Removing the password or deactivating the password is not sufficient. We recommend that you actually remove the data completely. Yeah. This is what the library does, and I think that's best practice. The copyrighted work must be removed from the system. Deactivating the students' passwords is not sufficient. Yeah. Okay. So you may ask yourself, I either didn't want to ask for or couldn't get permission. I've gone through the requirements of the TEACH Act, and sadly, it does not afford me any protection. What else do I have in this world? The answer is you may have a fair use defense. There are 4 things that you must think about in order to determine whether your instructor has a fair use defense, and they are the purpose and character of the use. That's the use that your instructor is making of the work. The nature of the copyrighted work, not your instructor's work, the copyrighted work. The amount and substantiality of the portion used compared to the entire copyrighted work, not compared to your instructor's entire work. And lastly, the effect of your instructor's use on the potential market for or the value of the copyrighted work. It's a lot, so we're going to go through each factor one by one. The first factor, the purpose and character of the use that your instructor is making. On the left of this slide are some uses that would tend to favor a fair use defense. For teaching purposes, for research or scholarship, if it's nonprofit, and this is where your question earlier about, okay, well, the Distance Learning Center is part of the University of California. On the other hand, we sometimes can have a commercial bent. That's where you need to take account of that. Are you using it for criticism or commentary, for news reporting? Is your use so transformative that it's not really the old work anymore at all? A classic example of that is, do we have any 2 Live Crew fans in the audience? Yes, okay. So you may be familiar with the 2 Live Crew rap version of Pretty Woman. The Supreme Court determined that because 2 Live Crew's use of Ray Orbison's original song, Pretty Woman, was so transformative, both because it was a parody and because it was rap as opposed to blues, was the original, that it satisfied this prong of the fair use defense. And actually they went on to determine that it satisfied all 4 fair use factors and therefore was a fair use. You must weigh all 4 factors individually and then collectively to make a decision about your risk. And I think that Extension has a tougher argument saying that it is solely educational and not at all commercial than someone on the main campus. That's the best that I can tell you. because that's what a jury will be instructed to do. On the right are uses that are not in line with fair use. Commercial uses, purely consumptive uses. You know, if you are ripping a song and then just listening to it yourself over and over and over again, that's a consumptive use. You're consuming the work. It's not a transformative use because you're not transforming the work. Likewise, making a copy of an article and then just letting all of your students consume it. Consumptive use, not transformative. For entertainment purposes, if you're doing it in bad faith, courts are not supposed to take this into account, but they invariably do. And if you fail to credit the author, again, not a copyright issue, a plagiarism issue, but it goes to the issue of bad faith. So this is the first factor. You would be able to say to yourself as you're looking at these two sides of the first factor, we do restrict access. And so our use is restricted in that way, and that helps us be more on the left side of the page than on the right side of the page. So I would recommend, as you're doing this analysis, that you take out a piece of paper and say, first factor, yay or nay based on, and then, you know, identify the factors that are relevant in that particular case. It's going to be different in every case. I want to talk a little bit more about the purpose and the character of use in an online context. You are going to have a much easier time making out a fair use defense or satisfying yourself in the privacy of your office that if challenged one day you would have a fair use defense in the online context if your use is restricted to students who are registered for the class, is password protective, the work is removed at the end of the session, and this is a big one, if the material is available streaming only, not downloadable. Why? Because if your students can download somebody else's copyrighted work as part of your course, then all the rest of this sort of doesn't matter, because once they've downloaded a copy, they can do whatever they want with it in the whole big bad wide world. I think the standard should be that you've used the best resources available to make sure that it's not downloadable. The other thing that some people do is they say, okay, there may be hackers out there who are going to be able to capture this, but maybe I should make it available in a format that is not that useful to them once they capture it. So it has lower resolution, or it has a watermark on it that is not going to make it optimal for people to whom they might want to sell it, that kind of thing. So let's be clear about where we are first. This is not a law that you must comply with or else you've broken the law and you're going to go to jail. This is not like thou shalt not drive drunk, right? These are factors for you to consider once you've gone through the analysis and you've decided, oh, if I use this work in the way the instructor wants to use it, the copyright owner might have a copyright infringement claim against us. If she were to sue me, what would I say? Could I say, well, I have a fair use defense? Well, I don't know, let me go through these 4 factors and figure out if I think I have a fair use defense. You will have a stronger fair use defense if you have streamed only than if you have also made available in downloadable format. The way to eliminate that concern, if it keeps you up at night, is to ask your sister for the keys to the car. You know, get written permission from the instructor. You know, in that regard, actually, copyright law is not unlike a lot of areas of law that affect your life every day. I wanted to talk about the spectrum of online courses. On the left are courses that seem more like traditional brick and mortar courses. I'm thinking mostly about classes that are flipped or hybrid classes where some of the class is online and some of it is in the classroom. Some of the hallmarks of these kinds of classes are that there are registered students only. This may start sounding repetitive to you, but that's because it's what I highly recommend. There are a limited number of students. It's password protected. There is a copyright policy in place. The work is not accessible after the session ends and it's streaming only. Way on the other side of the spectrum are MOOCs, Massive Online Open Courses. Why? Anyone can be a student. There is literally an unlimited number of students. No password is required. For most of these, there's no copyright policy. Is it available forever? Who knows? Can it be downloaded? Who knows? You're going to have a much easier time making out a fair use defense if you're on the hybrid side of the spectrum than if you're on the MOOC side of the spectrum. That's the first factor. So now you're in your office, you're thinking to yourself, if I have a problem, can I make a fair use defense? Let me go through the 4 factors. You've gone through the first factor. Here's the second factor. The nature of the copyrighted work. It's typically a quick analysis because the threshold for copyright protection is so low. Remember I said earlier that the originality requirement for copyright protection is so low that even something I painted would qualify, and soundly qualify. It's not a stretch. So in most instances, you're going to have something that is core creative content that is protected and whose use disfavors fair use. The bonus points for disfavoring fair use are that the work hasn't yet been published anywhere, because you're sort of breaking the story and that seems unfair. Again, according to the statute, not supposed to matter, but courts take it into account. Or if it's truly highly creative, like it's a fiction, or it's a novel, or it's a painting of an imaginary scene, not somebody's portrait, for example. You might have a better argument if you're on the left side of the page and you have something that has already been published and that is purely factual, for example, a newspaper article. But most of the time you're going to be on the right-hand side of the page. And then what I've shown you here are just some extra bonus points. The third factor, of course, is the amount and the substantiality of the portion used compared to the copyrighted work as a whole. And this is really 2 considerations, both the amount and the importance of the part that you took. So if it's a 10-page article and you took 9 pages, you're probably going to be on the disfavors fair use right-hand side of the page. If it's a 100-page book and you took 1 page, in terms of amount, you're going to be on the left-hand side, favors fair use side of the analysis. In addition, if the portion that you took isn't central or significant to the entire work, or if the amount that you took was the least amount that you could take to make the point that you needed to make in your own class, you're going to have a stronger fair use defense. If you took a lot, or if you took the critical part of the work, even though you really didn't have to make your teaching point, you're going to have a harder time making a fair use defense. The classic case about this is the one that involved President Ford's memoirs. Some of you, like me, may be old enough to remember the news. President Ford, of course, became the president when President Nixon left office, and when President Ford ended his presidency, he wrote his memoirs. And someone literally went into a bookstore overnight and gave it to a periodical that published a couple portions of the memoirs. The portion that they published, of course, was the part about Gerald Ford having pardoned Richard Nixon. Why? Duh, that was the part everybody wanted to read. That's the good part of President Ford's memoirs. The Supreme Court said in that case, okay, you only took a small part. And it was true, it was a very small part of the memoirs as a whole. But you took the central part, not fair use. So that's something to keep in mind when you're thinking about the third factor. Lastly, the effect of the instructor's use, that's the fourth factor. It has 2 components. The effect of the use on the potential market for the copyrighted work. If you've ripped a song and made it widely available to everybody for free on the internet, nobody's going to be buying it. That has an effect on the potential market for the work. And then the value of the work. It may be that you've somehow devalued the work through your use. And both of those are things that could prevent you from being able to successfully claim fair use as a defense. So again, another set of factors. If the instructor owns a lawfully acquired copy and made only one or a few copies of it, if there's no significant effect on the market or the potential market, for example, in the Two Live Crew Pretty Woman case, the Supreme Court said, we really don't think that people who would have been inclined to buy Ray Orbison's song are going to not buy it, because instead they're going to buy a perfectly acceptable substitute, the Two Live Crew version. We don't see that. There's no similar product offered by the copyright owner. And related to that is the copyright owner is not making licenses readily available or available at all. On the other hand, if your instructor's use could replace the sale of the work, and he or she made many copies and widely distributed them, repeatedly or over a very long period of time, then that's likely to impair the market or the potential value for the work, particularly if there is licensing available and you just chose not to license. So why do you have to take out a piece of paper and go through all 4 of these factors? Because in the end, you are going to use your best judgment to think about where you came out on each of the 4 factors and make, you do not need to take slide shots of the PowerPoint because it will be provided to you.
Okay.
Yes.
It's easier than taking notes.
Yes. By the way, may I just say this is a classic example. Who was it who was talking about, well, what if X, what if Y? Just ask and make an agreement in advance. You are going to sit down with your piece of paper and you are going to make the same holistic decision balancing all 4 of the factors that a jury would be asked by the judge to make if you had the misfortune of going all the way through a trial. And then you're going to make a decision. Do I think that this qualifies as a fair use, in which case I don't need to ask for permission? Or am I not really sure, in which case it might be safer to ask for permission? And by ask for permission, there's a broad range. You can go on the Copyright Clearance Center website and take one out online with a credit card, which is a very painless option, or all the way through to finding the copyright owner and writing an email requesting and getting an email back from him or her saying you can do X but you can't do Y. I want to talk about other options for finding works for your instructors to use in their online classes. Remember, the first element is, does the plaintiff own a valid copyright? Which dovetails with, should I or can I ask for permission? These are some of the free or low-fee resources that were provided actually by someone in extension to me as places where instructors are routinely referred to look for substitute, typically images, to use if they're having problems getting permission or if they're not comfortable with using the image that they originally wanted. The benefit of using free or low-fee resources is you don't have to do any further analysis because you already have permission. And so you don't have to ask yourself, gee, would I have Teach Act protection? Or, gee, what are my chances of a jury agreeing with me that the use that I made was a fair use? You can use these. You have permission to use them either for free or for a low fee, and then you can be done and you can move on to the next issue. We've been having conversations about individual discussions that you can have to get permission to use something. The conversation that my sister has with me asking to borrow my car, the conversation that you have over email that Natalie was discussing if she has an instructor who wants to use a particular work. The Creative Commons scheme is a way to scale those conversations. It may be that the article that Natalie's instructor wants to use is so popular that the author of that article literally does not have time to answer all of these emails from instructors like Natalie's who are diligently asking every time, may I use this? Yes, you may use it this way, but not that way. Because if he answered all of those inquiries, he wouldn't have time to do any of his other work. So he can say to himself, I know a way to take care of this problem. I'm going to go someplace really public and stand on a big box and shout to the world, all of you may use my article so long as you attribute it to me. Or, all of you may use my article so long as you attribute it to me and you only use it for non-commercial purposes. Well, we don't have marketplaces like that anymore because the world is too big and complicated, but we have the internet. So what the author in that instance would do is go to the Creative Commons website, pick whichever license matches his desires, and then make sure that wherever his work is reproduced, the kind of Creative Commons license that he chose is mentioned, and then all of us out in the big world know that we can use it that way, and we don't have to pester him every time we want to use it. If we want to use it in a different way than he chose a Creative Commons license for, then we have to ask him about that use. But as long as our use falls within the Creative Commons license that he chose, basically what he's saying is, anybody can use it this way. I'm in my office doing my work, don't bother me. I promise it's okay. Let's wrap up with a checklist because it's been a lot of information and it's always helpful to know, okay, I'm sitting down, I'm presented with this issue. What do I do first? I think the first thing you want to do is keep in mind, what do I or my instructor want to use? That's called identifying the copyrighted work. And how do I want, or does my instructor want, to use it? You need to know both of those answers before you can start going through the checklist. And the checklist is, once you've answered those first two questions, does someone own a copyright? You know, pre-1923, answer is probably no. Post-1923, which is, let's face it, most of what you're handling, the answer is yes. And the next question is, okay, so who? Because if I decide I want to ask for permission, I need to know whom to ask. Then you ask yourself, do I need permission? That is the answer to the three elements of a copyright infringement claim. Is if you go through those three elements and you don't think that there's a legitimate copyright infringement claim, then you're done and you don't need to ask for permission, right? Do we already have a license, like a library subscription? You can ask yourself, would a license be easy to get, for example, through the Copyright Clearance Center? Or has a license already been granted to the world and I just need to make sure I'm within that license to the world? Let me check on the Creative Commons website. You also might ask yourself, this is typically for the instructor to answer, do I want to ask for permission? Sometimes that can be a tricky question, usually not, but sometimes there are political reasons why people don't want to ask for permission, and so it makes sense to go through the Teach Act analysis and the Fair Use Defense analysis first. If you've decided you either can't get permission or you don't want to ask for permission, then you can go through the analysis of the Teach Act and the Fair Use Defense. In the end, the real question that you need to ask and that your instructor needs to ask is, what is the risk tolerance of the likely defendant, whether that be the university or an individual? And then, of course, you make your decision about what to use and how to use it. You are not alone. There is help available to you. If you have a question, do not sit alone in your office and wonder about what the answer might be. Call someone. In particular, the University of California Copyright website is a resource that you can use. I prefer the fair use guidelines that the UCI libraries have created. That's the second website that I've given you here. It's very, very helpful. And I typically tell faculty members that if they are having concerns about using someone else's work, our librarians are highly trained and spend a lot of time going through this step-by-step analysis with people, and they're terrific at it. And so I've given you their phone numbers as well. There are 2 in the main library at Langston and 1 in the science library. In the fall, we give a presentation about your copyrights, proper care, and feeding, which we didn't discuss at all today. That's the other side of the coin. And then in the spring, respecting the copyrights of others, which is in some respects very similar to what we discussed today. You must do the analysis individually each time based on your use, not based on Johnny's use. And you must do it based on the work and the use you want to make. It's medium neutral. If you're going to link to something, make sure that it's legitimate. If you have reason to believe that the thing you're linking to was improvidently posted, then your safest option is to link to something else. Thank you all very much. I really appreciated this.